What's up, everybody, and welcome into a vacation edition of The Lawyer You Know. And today we're going to take our first look at the case against Jay-Z. And while we're not going to do a deep dive into the totality and the facts specifically against him in his case, some major legal filings have happened. And the most explosive was a federal judge's reprimand to Jay-Z's lawyer. And you may have heard about him before. You may have heard of him before. He may have been part of one of the top 10 wildest moments of the year 2024. But there's just too much going on to save it any longer. We are going to discuss that court order. We're going to give a little bit of a background. We're going to talk about whether or not shady things are happening in the background against Jay-Z by plaintiffs' lawyers. Is there extortion going on? What does this look like? Are there any legitimacy? Is there any legitimacy to the allegations and the complaints made against Jay-Z and toward the lawyer suing Jay-Z? All that and more in today's video. Make sure you guys hit the like button. Make sure you're subscribed. Let's get to it. So I'm saving some of the deep dive into all of the different things going on in this case because there is so much for a podcast episode that's going to be dropping in January from a guest that you guys are going to love, that you have requested a ton of. That is the podcast topic that they have requested so far. So I'm saving some of it. But when I saw this order come down and I saw the judge's language in it, I said, uh-oh, is this bad for Jay-Z? Is this judge showing what kind of case this is going to be and how they're going to look at this case? And I think it's important to just recognize the players involved, what's happening, whether or not it's normal, whether or not this is just the normal course of business for lawyers and lawsuits in the civil justice system, or is there something more here? Because there's no doubt in my mind, Jay-Z and his lawyer, what they're saying publicly, and even what his lawyer is filing in this case makes it look like and seem like something abnormal is happening here, that he is being targeted because of his stardom, because of his money. He is being extorted, and that this plaintiff's lawyer specifically may have a reputation for doing things underhanded or shady or breaking the court's rules, because that is exactly what's being put out there publicly. So we're going to start somewhat from the beginning of the back and forth civilly into this case. We have a situation here where by now everybody on this channel knows what's going on with P. Diddy. Federal charges, dealing with RICO, but specifically abusing people, taking advantage of people, hurting people left and right in the industry, even some minors. The allegations have come forward. There are criminal charges with a lot of those things, especially with the RICO, and there are civil allegations and civil complaints with all of the allegations, including the minors so far. And we're going to see whether or not more criminal charges come for the minors involved that have at least been victims allegedly in the civil court system. So now that we have already seen exactly what's going on with P. Diddy, we've done a bunch of videos on it. If you guys want to go check the playlist, you can. We have multiple videos with P. Diddy. Even my dad has come on for some videos to talk about the federal allegations against him. Criminally speaking, there are also civil allegations against him. And we talked about how the hundreds, if not thousands of people have come forward alleging criminal behavior against P. Diddy. If I mix up their names, P. Diddy and Jay-Z, I'll do my best. But, once in a while that a slip of the tongue may happen. But the criminal charges are just against P. Diddy so far. Hundreds, if not thousands of allegations against P. Diddy, and hundreds of lawsuits have been filed or in the process of being filed against P. Diddy. And Tony Buzbee is the plaintiff's lawyer at the forefront of most of those civil actions. Now he's partnering up and working with different firms in different jurisdictions, which is going to come up in this case as well. And he's also got a lot of unnamed co-conspirators and unnamed other celebrities and unnamed defendants that he mentioned in press conferences would be named later. Well, guess what? One of those unnamed celebrities has been named now, and his name is Jay-Z. And these are just allegations against Jay-Z, allegations which he has adamantly denied, but they're of similar heinous and sexual nature, and the abuses that were very similar to what has been alleged against P. Diddy. So Jay-Z obviously doesn't like that. That's not good for him. That's not good for his image. That's not good for anything. So what does he do? He hires a high-powered, if not the high-powered lawyer to the celebrities, Alex Spiro. And if you don't know that name off the top of your head, you may remember Alex Spiro represented Alec Baldwin. Alec Baldwin is not his only celebrity client. He's known for representing a lot of celebrities, which can be a good thing to have that kind of reputation. Or we'll see if sometimes having a reputation that precedes you might be a bad thing. If certain judges or certain lawyers or certain jurors look at it and think, oh, I don't trust this guy because of X, Y, and Z, or because of his reputation. And we'll see how that continues as this case goes on, because we're going to see part of what happened today when we read the judge's order and what she thinks about some of his antics. And I think it's important to remember that lawyers that are the lawyer to the celebrities, sometimes, I mean, most lawyers, especially big shot lawyers, especially top lawyers, especially celebrity type lawyers, you would think they have the upper hand, right? Their clients are just going to listen to them. They're the big bad lawyer. They get to choose which cases they want. They've got a line out the door of people wanting to come and hire them. A lot of times, if lawyers are high profile, or if they're famous, or if they have people knocking down the door to try and hire them. And a lot of lawyers turn away cases, right? Private lawyers pick and choose their cases. So with that, and in that relationship, usually the lawyer has the upper hand. Usually the lawyer is the one that is going to make the decisions on what's going to happen in a case. Unless you've got billionaire, mogul, celebrities that are just at a different level, which you have P. Diddy and Jay-Z, which are at that top, tippity top level of client, of celebrity, of power, of money. And sometimes that can be a dangerous thing. And sometimes, lawyers can either try to, I'm not saying that's what's happening here, okay? But you'll get the context when we read the judge's order. Sometimes lawyers will maybe do things they wouldn't do in a normal case, maybe push a little harder, maybe say things that are a little extra, be a little more aggressive because, wealthy clients like nothing more than a bulldog. We've had lots of lawyers say, or lots of clients come in and say, we want a bulldog of a lawyer. Is that type of lawyer you are? And we say, yeah, we're bulldogs, we're tough, we're harsh, but we're not going to do anything unethical. We're not going to make any accusations that we don't have a good faith basis to make. We're not going to do anything. We're not going to extort people into situations. We're not going to go and pay witnesses to lie or tell somebody to lie or use our influence inappropriately on any judges or jurors or witnesses, because that's just not something we're going to do. And guess what? It can be really hard if you haven't made that decision prior to getting a big client, a wealthy client, a celebrity client. And sometimes, listen, celebrity clients, sure, that can be cool, but a wealthy client is a wealthy client. They're going to pay you a lot of money, and you as a lawyer can make a lot of money on that case. And you've got to make a decision before a high dollar, high profile case comes to you on how you're going to act, what your morals are, what your ethics are. And that's really important. Every lawyer's got to make that decision early on. You can't wait until you're faced with the question to make that decision, if that makes any sense. So everything in this case is on steroids because of the players involved. And one of the things that has been discussed in this case is the demand letters. The demand letters sent to Jay-Z, and I'm sure we're going to hear it sent to other high-profile clients, and how defendants publicly use those demand letters. In this case, Jay-Z has made some public comments, and I want to read some of them to you here so you can kind of get the vibe of how they're setting up how this case is going. My lawyer received a blackmail attempt called a demand letter from a lawyer, quote unquote, named Tony Buzbee. He shared in the statement also that he said what he had calculated was the nature of these allegations and the public scrutiny would make me want to settle. No, sir. It had the opposite effect. It made me want to expose you, speaking to Tony Buzbee, for the fraud you are in a very public fashion. So no, I will not give you one red penny. So Jay-Z saying it's an extortion, a blackmail attempt, called a demand letter, and you threatened the public court system, you threatened a lawsuit, you threatened all this stuff for money. Sounds a little like extortion, sounds a little like blackmail, right? Well, demand letters in the civil justice system are not only commonplace, they're basically something that should be done. They are the appropriate way to handle a civil case. You may ask why that is. Really, in an effort to not file lawsuits that don't need to be filed, to not publicly drag people through the mud if they don't necessarily need to be. Because in the civil court system, all you can really get is money for the most part. There are specific performance where you can force somebody to do things sometimes, but the vast majority of civil lawsuits are about money. So if all you can get is money, and you can write a letter and say, hey, I'm going to sue you. We both know I'm going to win. Let's see if we can agree on the amount of money. You can pay me now. And we don't have to clog the court system, right? The cases that can go into the court system that can use judicial resources, judges' times, JA's times, which is a judicial assistant, bailiff's time, juror's time, if we get to a trial, are only the cases that must get there. If we can handle this civilly and come to an agreement about the money, we don't have to clog the court system. It's actually seen as a sign of good faith. Judges and courts usually prefer to see parties use a demand letter and settle a case pre-suit if they can. Resolve cases before you get into litigation. Now, certain wording of a demand letter can be used against you depending on what you say, and that's why it usually comes from a lawyer and not the client's own words in a demand letter. But generally speaking, they're not admissible at trial. They're negotiations, settlement conversations. Those are protected. A jury is not going to hear what you put in a demand letter for the most part as if you're extorting them or demanding money out of them, because by the time it gets there, the jury knows that. The jury knows that the plaintiff sitting over there is suing the defendant, saying, sitting over there. The plaintiff said the defendant did something. The defendant denies it. The plaintiff says they owe money for damages and the defendant denies it, or at least disagrees with the amount, which is basically the elements in the demand letter. And a lot of times lawyers will say, hey, we think we're going to win this one for X, Y, and Z. Here's what the law says. Here's what we both know you did. Now let's talk about if we can get to a dollar amount. And a lot of times that's where it breaks down. But generally speaking, demand letters are used in almost every case. Most lawyers, if not all lawyers, know that. And most judges, if not all judges, know that. So whenever somebody publicly says something like, and we've had it happen before in some of our high profile cases, and for the most part so my dad has represented a lot of high profile clients on the criminal side, but we've only really, from my perspective, most of the high profile parties that are involved in my case would be people we're suing. And, a lot of times you don't see this type of reaction from an insurance company or a big company. We've sued a lot of them. They won't come out and say it's blackmail or extortion, but sometimes high profile individual defendants will come out and say something like this. And, it's unfortunate, but I get it. They want to, if they feel like you're wrongfully suing them, they have the right to say things. They have freedom of speech. They have the right to defend themselves. They have the right to say, I didn't do this. And that's perfectly fine. But we know as plaintiffs' lawyers that this is not going to come back to bite us. They act like, well, once we tell the judge what you put in this demand letter, you're going to be in trouble. And it's like, that's not really the case. I write a demand letter basically expecting the judge to read it, right? Just like you write emails and we say, expect your mom to read it or expect it to be public. Well, when it comes to demand letters, let a judge read it. Here's what you did on this date. Here are the out-of-pocket expenses. Here's the medical bills. Here's the damages that you caused my client. Here's how much money we want. And by the way, you also usually can't use the amount demanded in trial to say, say we want $1 million. That's the demand we make. But at trial, we ask for $5 million. They can't go back and say, well, in the demand letter on this date, you only asked for $1 million. Because it's a different case. There might be more treatment. There might be more damages we didn't know about 3 years ago when we wrote the demand letter. Things can change, and those are confidential settlement negotiations in a demand letter. Well, although lawyers and judges know, it doesn't always stop a lawyer from trying to call a demand letter shady. In the motion to dismiss in this case that has been filed, and we're going to see the judge reference a slew of motions filed by Spiro, right? And you got Spiro, big personality, celebrity type lawyer. You got Buzbee, huge personality, celebrity type lawyer. And you got Jay-Z. Those are the three people involved here. So everything's going to be on steroids here. But in the motion to dismiss, Spiro accused Tony Buzbee of running a sprawling extortion saga, a saga whose aim is based and measured in dollars. It's an extortion campaign that was cynical and calculated to force payment of an exorbitant sum of money. The defendant would have to pay X millions of dollars, irrespective of the truth, or else. And again, that does sound like extortion. It does sound like a threat, right? But that's exactly what a demand letter is. It's a threat, but it's more of, can we resolve this pre-suit without filing a lawsuit? And if the answer is no, that's fine. We're going to file a lawsuit. And I always tell my clients, I've had friends ask me, hey, can you just write a demand letter for us? We don't have to file a suit on this. I don't like to do that. If I'm going to write a demand letter and I'm going to say, if we don't settle this case, I'm going to file a lawsuit, I want to be, my word is my bond, right? If I write that our law firm is going to file a lawsuit, now things can happen where the client says, never mind, I don't want to go through all this. And that's the other thing, right? Especially for victims, if you can settle the case pre-suit and they don't have to be re-victimized and they don't have to go through the tragedy that is the wrongful death and their loved one who died in a car accident or getting hit by a truck or because some company screwed up or cut corners and put profits over people and this person ended up dead and they don't have to relive that and you can settle it pre-suit, you better believe I'm going to try to do that for every single one of my clients. I don't want to have to put them through that again. And if a defendant doesn't have to publicly be dragged through it and go to litigation and spend all the money on lawyers because they're also going to still have to pay my client in the end, then that's the way it should go. If everybody agrees a wrong has been committed. If the defendant maintains that they did nothing wrong, then they should let it be handled in the court system. And if a victim says they did do it, well, let's go prove it. And it's tough, but they got to go through the court process and they got to prove that they did it. But for lawyers to write things like they asked for millions of dollars or else, it's like, yeah, or else we'll file a lawsuit because that's legally the steps that we are allowed to take. And to make those threats sound nefarious, a lot of the general public will get behind that. Okay. A lot of people watching this may disagree with me and say, that sounds like extortion. You should never do that. Okay. That's fine. And that's why defense lawyers like to publicly make statements like that. They tried to extort me out of money. If it was true, they would have just filed the lawsuit. No, it's not how it is. That's not how plaintiffs' lawyers do it. And that's not how judges want you to do it. Judges want you to try to resolve it pre-suit. Throughout the case, if I had a nickel for every time a judge told me, why don't you guys just go resolve this? Why don't you go talk in the hallway? Why don't you guys get on a call and see if you can settle this? Judges want us to settle cases. They don't want us to waste judicial resources if we don't have to. The only cases that should go to trial are a small percentage, the ones that really we have major disagreements either on the facts or the amount of money that a case is worth. More from the motions filed by the defense. When the defendant refused to pay and instead took measures to establish his innocence, this unnamed plaintiff and her self-promoting counsel, whose name has been splashed across headlines and press conferences under auspices of representing her, went to extraordinary lengths to shut down a fair defense. But those efforts too failed. And I think the only, legitimate little nugget there that he's saying how they're trying to shut down a fair defense is the plaintiff is still trying to remain anonymous. Because that tactic is inconsistent with a genuine effort to determine the truth or falsity of these allegations, as opposed to an effort to produce a quick, extortionate settlement, the defendant is respectfully seeking either dismissal of the allegations or disclosure of the plaintiff's identity. I will just let you know, most of those types of allegations that, it's extortion, he's trying to get money, he's doing press conferences, none of that's going to make him dismiss the complaint, right? At best, what he's saying is, in order for a fair defense, we need to know the name of the plaintiff, so the judge may give them the name of the plaintiff. We'll have to wait to find out when we read the judge's order together. So that's what's happening here. By the way, we have gone, almost 20 minutes and we didn't mention who Jay-Z is married to, which is Beyonce, one of the biggest celebrities on the planet. I feel like she's bigger than Jay-Z. I could be wrong. You guys can disagree with me, but she's involved as well, right? Her husband, their kids, and this is disgusting behavior that he has been accused of. So they have to protect that reputation. And the way that they've started to protect it is with public comments and language. I don't know if I want to call it unnecessary language. I'll call it some nasty language. People got so mad when I don't remember if it was me or my dad that said Luigi Mangione's lawyer, who is a female and a stud lawyer and probably a bulldog, right? If you have that position she had for 20 plus years, the prosecutor's office, to work your way up to be one of the top prosecutors there, and then now to be a criminal defense lawyer getting high profile cases, she probably is a bulldog. And I don't think she would take any offense to anything that my dad or I have said in any video. But just to not make it to one gender, which I don't think I have, I'm positive I said Alan Jackson said some nasty stuff during Karen Reed's case, and saying somebody says something nasty doesn't mean they're a nasty person. This isn't a derogatory name calling situation. I hope people know that have followed me for long enough, for the years I've been shouting thousands of words on the internet, that I don't like to attack people personally. Some people beg me and wish I would attack especially lawyers personally. I really try not to do that. But Alex Spiro had some nasty words for Tony Buzbee and this case. We've read some, but he also pointed out Tony Buzbee has had some misconduct on several other occasions, including during his time representing Los Angeles socialite Rebecca Grossman. Buzbee's behavior while representing that defendant, was reprimanded by a presiding judge in a December 18th legal filing. The presiding judge rebuked Tony Buzbee, declaring, "We cannot have the defense violating pretrial rulings and exposing the jury to evidence that contradicts those rulings," and reprimanded him for his conduct, stating that if it continued, the court would consider financially sanctioning Buzbee and reporting Buzbee to the state bar. So he puts that in the filing for this case. How is that relevant, right? Now, what he's trying to do is argue that we can't just take what Tony Buzbee says on face value. He also made allegations Tony Buzbee is basically practicing law in New York without a license because he didn't pro hoc vice in. So he's making those allegations, but he's really dragging his name through the mud, bringing up old crap, right? Why are you bringing up old? That's a quote from a movie, but it's like he's doing it. He's trying to make Tony Buzbee look as bad as he can to this court. He is trying to let this court say, you know, a lot of lawyers, Judge, you can read, you can take their word for it. You can give them the benefit of the doubt. They're probably not going to lie to you. They're lawyers. They're members of the bar. They're here in good standing, but not this Tony Buzbee, Judge. He doesn't practice here in New York. And look, in some of the other jurisdictions he's practicing, he's been reprimanded before. Be careful what you wish for. Right? There's some irony here. He also said that just the factual inconsistencies in this case, the timeline and possibilities, the lack of corroborating evidence make the plaintiff's allegations wholly unreliable. And she has even admitted that there are some inconsistencies in her story. He also said the defendant, Sean Carter, aka Jay-Z, has built an impeccable reputation. He has never been accused of, let alone engaged in, any sexual misconduct. Well, until now. He'll never be able to say that in the future if this is alleged again, because it has been alleged here. So you can see there, protecting a high-profile celebrity client, going hard for them. Tony Buzbee said his client only sought a confidential mediation. Since he sent the letter on her behalf, Mr. Carter has not only sued him, Tony Buzbee, that's right, Jay-Z has sued Tony Buzbee, but he has also tried to bully and harass me and this plaintiff. His conduct has had the opposite impact. She is emboldened, and I'm very proud of her resolve. So both sides say, hey, you're not gonna big league me. I'm gonna big league you. You're not gonna pat me on the head. You're not gonna sun me. I'm gonna sun you. And they're both more and more emboldened, digging their heels in. And here we go. There's also more we're going to hear from the actual judge's order about what's been going on back and forth. But before we get to the judge's order, in case you don't believe me about demand letters, let's take a look at Federal Rule 408, compromise offer and negotiations. Prohibited uses. Evidence of the following is not admissible on behalf of any party, either to prove or disprove the validity or amount of a disputed claim, or to impeach by a prior inconsistent statement or a contradiction. So you cannot use compromise offers and negotiating, which is a demand letter, by the way. You can't use it to prove or disprove the validity, meaning the validity of any disputed claim or the amount of any disputed claim. You also can't impeach somebody with a prior inconsistent statement or a contradiction that comes from a demand letter. These demand letters are protected. The judicial system wants lawyers to send demand letters. There are even certain cases where you have to send a demand letter. It is a condition precedent to filing the complaint. Furnishing, proffering, offering, or accepting, promising to accept, or offering to accept a valuable consideration and compromising or attempting to compromise the claim. So you can't even hold it against a defendant if they're like, okay, I got your demand letter. I'll offer you $10,000, not $1 million. You can't use that later. The defense offered $10,000. So they admitted that, they owed me money. You can't use it for that because we want to encourage settlements if both sides can agree it's time to settle. Not force settlements, but encourage them. Conduct or a statement made during a compromise negotiation about a claim, except when offered in a criminal case and when the negotiations related to a claim by a public office in the exercise of its regulatory, investigative, or enforcement authority. By the way, this isn't limited to demand letters, right? Same thing in mediation. If you have a settlement conference, if I write an email at the top where it says confidential settlement negotiations or discussions, those things are protected by rules like this in most jurisdictions, a federal case. So I want to read the federal rule. Now, there is an exception. The court may admit this evidence for another purpose, such as proving a witness's bias or prejudice, negating a contention of undue delay, or proving an effort to obstruct a criminal investigation or prosecution. So those are the only reasons you can use it. None of which, in my opinion, are going to apply in this case. All right. So now we are going to get to this court order. After many, many motions and filings back and forth, there are a couple questions that are open here that the court is going to answer. Will the court just dismiss the case outright against this plaintiff? Will the court reprimand or sanction Tony Buzbee? These are the things that Alex Spiro and Baldwin's team are asking for. Will the court force the plaintiff to reveal her name? We've seen and we've talked about in other videos in the P. Diddy situation. Those are criminal cases. This is civil. So again, a little bit of a difference there. We'll hear the judge talk about that. But will she force the judge, or will she force the plaintiff to reveal her name? And we saw in the P. Diddy cases, some of the plaintiffs did have to reveal their name, some didn't. All right, let's take a look. And again, like always, if you guys can't read it perfectly, don't worry. I am going to read every word of this court order. Let me make sure you guys can see it on the screen, though. All right, here we go. So this is Annalisa Torres, district judge in New York. By the way, this is in the United States District Court, Southern District of New York, federal case. And as you can see, Jane Doe. And we're going to talk about when we see some of the scathing remarks in this order, do judges ever get worried? Right? And that's something we're going to talk about as well. Are judges ever nervous to go at certain high-profile lawyers, which we have a couple in this case? Well-known lawyers for different reasons. Plaintiff Jane Doe filed this action on October 20th, 2024, alleging a violation of the New York City Victims of Gender-Motivated Violence Protection Act. By order dated November 6, 2024, the court provisionally granted plaintiff's motion to proceed anonymously, explaining that the defendants had yet to appear in this matter and that the balance of interest weighing for or against anonymity may shift as her suit continues. So while the judge has already allowed her to continue anonymously, the judge has said, listen, this may change. So just understand that this may change. On December 8th, 2024, the plaintiff amended her complaint to add Sean Carter, known professionally as Jay-Z, as a defendant. Okay, and we knew that. Amended, added him in because, listen, you can do a demand letter and you can file a lawsuit or threaten a lawsuit. But then there's the next step. You can even threaten a lawsuit, put an unnamed celebrity in there, and then tell this person you're negotiating with, you are that unnamed celebrity. So, because some people think, you ain't going to file the lawsuit. I'm going to call your bluff, et cetera, et cetera. Well, he did. He called their bluff. Plaintiff again sought leave to proceed anonymously, but this time Carter's counsel appeared and moved to deny her motion. In the alternative, to dismiss her amended complaint pursuant to Federal Rule of Civil Procedure 12b-1. Carter also moved, here's all the things Carter's asking for an expedited hearing on the issue. The next day, Carter's attorney filed a letter containing a declaration from an associate at his law firm recounting a phone conversation she had with an unnamed woman who claimed that plaintiff's counsel encouraged her to lie about her experience of assault. So, again, Alex Spiro, Carter, aka Jay-Z, his lawyer, is sending information to the judge saying, we have spoken to another person that has talked to Tony Buzbee, and Tony Buzbee encouraged her to lie and say Jay-Z did things that he didn't do. And this is supposed to in turn tell the judge these unreliable facts should just be dismissed outright. It's just never going to be enough. It's never going to be enough to deny them. Now, what it can do for certain judges is color them against a guy like Tony Buzbee. This is what he does. It's so shady. But the judge is not the fact finder here. Spiro's also arguing that Tony Buzbee is filing these lawsuits without a good faith basis. He's just taking anybody that's willing to say anything and sue and add leverage against high-profile defendants. On December 13th, and if you notice, the judge is saying, on December December 8th, the next day. Then just 4 days later, on December 13th, Carter's attorney filed an additional letter alerting the court to a recent published interview of plaintiff on NBC News. In the interview, plaintiff, speaking anonymously, explained her allegations against the defendant and her reasons for coming forward now. Carter's lawyer, which is Spiro, points to the interview in which the plaintiff admitted to inconsistencies in her story as evidence that the plaintiff's claims have no factual basis whatsoever. So first off, having inconsistencies in your story is not the same thing as having no factual basis whatsoever. Additionally, having inconsistency in your story, how many cases have we seen in criminal side and civil side come forward where a witness has inconsistencies in their story? And guess what that means? The fact finder, which is probably going to be a jury in this case if it gets that far, is going to determine whether or not the story is true or false, whether they believe some, all, or none of what a witness has to say. It is up to that jury if the this defense lawyer, Alex Spiro, can go and crush a witness, even a victim, on cross if they think they're lying and there are major inconsistencies in their story. Go for it. Be all you can be on cross. That's what it's for. It's fodder for cross. A judge is not going to dismiss a complaint because there are some alleged inconsistencies in a plaintiff or victim's story. It's just not the right time for that. Now, summary judgment comes if all the evidence says one thing and one victim says the other. By the way, I've seen some cases get past summary judgment on just that. But at that point, if a judge summary judgments out the case and says no reasonable juror could ever find in favor of the plaintiff, all of the evidence is in opposition to what the plaintiff says, then we'll see. But that is a totally different standard. That's a totally different part of the case than the motion to dismiss phase we're at now. He also argues that plaintiff's counsel violated Federal Rule of Civil Procedure 11B by failing to undertake a reasonable inquiry into the facts before filing the complaint. So this is a situation where he's saying Tony Buzbee is just telling people to say anything they can against Jay-Z or P. Diddy because he wants to file all these lawsuits. He is not making a reasonable inquiry into the facts before filing the complaint. Now, we did a breakdown of a press conference where Tony Buzbee spoke, and he said exactly that they had thousands of calls and they vetted them to the absolute best of their ability. And here's the other thing, as a plaintiff's lawyer, and I said this during the video, we can't know for a fact if our client is telling the truth, but we do have a duty to reasonably look into it, make a reasonable inquiry. If it is so obvious that what our client is saying is a lie or is wrong, we should not take the case, and that could be a frivolous lawsuit and we could be in trouble. That's basically what Spiro is saying here. And failing to seek admission pro hoc vice to this court. So he's saying Tony Buzbee didn't do that appropriately either. Carter's attorney requested an expedited briefing schedule for a motion to strike the First Amendment complaint under Federal Rule of Civil Procedure 11C2 and 12F. The next day, and there's a vibe here to this judge, Carter's counsel submitted yet another filing, a motion for an emergency order directing the preservation of evidence and striking the amended complaint under Rule 12F. So now we see the judge's analysis and her decision. First, we're going to handle the motion to proceed anonymously. In deciding whether a plaintiff may proceed anonymously, courts balance the plaintiff's interest in anonymity against both the public interest in disclosure and any prejudice to the defendant. The Second Circuit has laid out a non-exhaustive list of factors to be considered. Whether the litigation involves matters that are highly sensitive and of a personal nature, whether identification poses a risk of retaliatory physical or mental harm to the parties seeking to proceed anonymously, or even more critically, to innocent non-parties. And again, that one's going to be important. Whether identification presents other harms and the likely severity of those harms, including whether the injury litigated against would be incurred as a result of the disclosure of the plaintiff's identity. Whether the plaintiff is particularly vulnerable to the possible harms of disclosure, particularly in light of her age, his or her age. Whether the suit is challenging the actions of the government or that of a private party, that's important to remember as well. Whether the defendant is prejudiced by allowing the plaintiff to press her claims anonymously. Whether the nature of that prejudice, if any, differs at any particular stage of the litigation. Does she need to make that decision now as a judge, or can she wait till later? And whether any prejudice can be mitigated by the district court. Whether the plaintiff's identity has thus far been kept confidential. And again, that's why you mentioned the NBC interview. If she would have said her name, the judge would have been like, yeah, I'm not going to keep her anonymous here if she's going all over the news and saying her name out loud. but she hasn't. She kept it confidential there, and she's trying to keep it confidential here. Whether the public's interest in the litigation is furthered by requiring the plaintiff to disclose her identity, that might be a big one. Whether because of the purely legal nature of the issues presented or otherwise, there is an atypically weak public interest in knowing the litigants' identities, and whether there are any alternative mechanisms for protecting the confidentiality of the plaintiff. A court is not required to list each of the factors or use any particular formulation as long as it is clear that the court balanced the interests at stake in reaching its conclusions. And now we're going to get how the judge balances these and whether or not this plaintiff can continue anonymously. Here, the weight of the factors tips in favor of allowing plaintiff to remain anonymous, at least for this stage of the litigation. So there's our answer. She can remain anonymous. Again, Jay-Z loses. Not great, but not that big of a deal because, again, just at this stage of litigation. But is this an omen for how this order is going to go for Jay-Z? Factors 1, 2, 4, and 7 weigh strongly in favor of anonymity. In her amended complaint, plaintiff alleges that the defendant drugged her and AR'd her when she was only 13. Courts in this district have recognized that allegations concerning that type of assault are highly sensitive and of an extremely personal nature. Plaintiff is particularly vulnerable to the harms of disclosure. According to her amended complaint, she continues to experience depression, post-traumatic stress disorder, and a seizure disorder associated with the stress of her assault. Denying disclosure in part because of a risk it posed to plaintiff's already fragile mental health has been okayed in other courts, in other cases. Moreover, plaintiff's counsel asserts that many of his other clients who have filed similar lawsuits against Sean Combs claim to have been threatened by Mr. Combs for their decision to speak out. And guess what? Some of that has happened in this case, where Buzbee says Jay-Z is threatening, coercing, calling, even trying to pay people to say bad things or do bad things to Tony Buzbee or to this client. So Tony Buzbee is making those allegations publicly. And what I'll say, love him or hate him, some people love Tony Buzbee, some people hate Tony Buzbee. He's big, he's loud, he's proud. He is, out there, he's in your face. He's a bulldog as well. We got two bulldog lawyers here. But he is using the public, and he's using the language from the statutes in a lot of this. He talked about reasonable inquiry when he talked about the thousands of calls that he vetted and only ended up with 100. He has also mentioned that these big shot clients are doing things to bully him, his clients, and his witnesses already in the background. And that is relevant to this part. And the judge does make note of that in her decision, which is a win for Tony Buzbee and his client. Most importantly, plaintiff's continued anonymity. And finally, although plaintiff sat for an interview with NBC News concerning her case, NBC allowed her to conduct the interview anonymously. Granted, several factors weigh in allowing plaintiff to proceed anonymously. Plaintiff is challenging the action of private parties. So now we're going to see where the balance comes in, because there are some things that weigh in favor of her revealing her name. She's suing a private party, not the government. And given the media attention surrounding the case, the public has a substantial interest in this litigation, separate and apart from its general interest in an accused being able to publicly confront an accuser. I would agree 100%. So if the judge would have said, you got to let your name out, there are some factors that weigh in that manner, and it may change in the future based on some of these. Alternative mechanisms may exist to protect confidentiality. And here's what I like. This judge is smart. Namely, the redaction and sealing of documents. So what's the judge say? One of the things is, if you can come up with a way that doesn't reveal her name publicly, but still reveals it to the defendant, can we fix a lot of these issues? And how would we do that? Well, we disclose it to the defendant, but anytime it comes up in a public document, we redact it. Any documents that may be touchy, we make confidential, we seal them. So there are other ways that may happen in the future. Sealing documents. Most importantly, plaintiff's continued anonymity may cause prejudice to the defendants, making it more difficult for them to collect the facts necessary to mount a defense as appropriate, challenging plaintiff's credibility. Identifying the most significant form of prejudice to the defendants as the discovery disadvantage that plaintiff's anonymity would present, the court does not take such prejudice lightly. Nonetheless, at this exceedingly early stage in this case, The factors counseling against disclosure outweigh those that counsel in favor. Accordingly, the plaintiff's motion to proceed anonymously is granted. Plaintiff is advised that because of the balance of these factors, it will certainly shift as the case proceeds, especially if and when the parties engage in discovery in earnest. The court intends to revisit this decision at a future date. That to me indicates that at least Jay-Z and his team is going to know this plaintiff's name at some point and when discovery, and that's exactly how it should be. They've got to be able to mount the defense. They've got to be able to call witnesses and say, no, this person told a completely different story to me, or I have a letter or an email or a text message from this person that shows what they said is a complete lie, and you can't get that if they remain anonymous. So I think the right decision will be to reveal this person's name to the defendant and his team, maybe not allow it to go public. We'll see. Now let's handle the remaining motions, which is when it really gets spicy. Since Carter's attorney first appeared in this case 17 days ago, he has submitted a litany of letters and motions attempting to impugn the character of plaintiff's lawyer. So, by the way, when the judge says things like, we're going to allow this plaintiff to go forward anonymously, she's claiming that she has all of these injuries, and has all these damages, and she's got to treat for X, Y, and Z, and she's still dealing with PTSD. That tells you the judge ain't just throwing out what this plaintiff said because the lawyer's like, this is wholly unbelievable, and the inconsistencies and timeline and possibilities make what this client is saying obviously a lie. Well, not to the judge, because the judge knows how to look at it. And right now, when you look at the complaint, you take what the plaintiff says as true, and that's how you make your decision on the motion to dismiss. And guess what else? Dragging Tony Buzbee's name through the mud in public filings and letters you're giving to the court is not working when the court says something like attempting to impugn the character of plaintiff's lawyers. Many of them expounding on the purported urgency of this case, describing plaintiff's counsel as self-promoting and accusing him of extortion, requesting to be heard on an expedited basis, accusing plaintiff's counsel of exploiting the legal process to generate media attention, asserting that plaintiff's counsel seeks only to benefit himself, requesting the shortening of a deadline from 21 days to 1 day, describing plaintiff's counsel as willing to blatantly violate the core ethical obligations of all attorneys, and requesting a hearing on the motion the following day. Scathing, nasty comments from Spiro about Tony Buzbee. That's the only way to describe him. He went hard at Tony Buzbee. I don't know if he doesn't like him personally, but professionally speaking, he is not a fan of Tony Buzbee and is willing to try and make him look as horrible as possible before this case even starts before this judge. That's really the only way to look at it, because legally speaking, you're not going to win any of these motions by attacking the plaintiff's lawyer. They're filing a lawsuit against the plaintiff's lawyer. If they have facts and they think he did something wrong and he lied and he made things up and he committed fraud, fine. That's fine. Go for it. File a lawsuit. But handling it by writing letters to the judge, it didn't work with this judge. Also, I don't think the judge likes, we need to have a hearing the following day. We need to drop the deadline from 21 days to 1 day. Carter's lawyers' relentless filing of combative motions containing inflammatory language and ad hominem attacks is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. The court will not fast-track the judicial process merely because counsel demands it. This is about as bad as it gets for a good lawyer. Now, if you're just a negligent lawyer and you're a schlep and you mess up and you don't care and you're sloppy, sure, judges will hand it to you. But Alex Spiro is an excellent lawyer, an exceptional lawyer, incredibly smart, incredibly good at what he does, had one of the biggest wins of the year in 2024. So that's not him. He's not a bad lawyer. He made some purposeful decisions to make some attacks. And I guess it could have gone the way that the judge looks at Tony Buzbee and is like, he's a hack. He's unethical. I can't let him get away with anything. Or a judge could look at it like this. And I told you, the only time I've really been reprimanded on a much lower level was just filing a motion for sanctions. And a judge was like, we don't do that to each other around here. Lawyers don't do that to lawyers. And I vehemently disagreed, but it was a very polite motion. And there was nothing wrong with my language in it. The judge didn't have any language like this, but certain judges hate when you go at certain lawyers, even a little bit. And if you get a judge like that and you go at the lawyer a lot, this is the type of answer you're going to get. Carter's lawyer's relentless filing of combative motions containing inflammatory language and ad hominem attacks is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. The court will not fast track the judicial process merely because counsel demands it. Moreover, although Carter's attorneys assails plaintiff's lawyers as having a chronic inability to follow the rules, so Spiro said that Tony Buzbee has a chronic inability to follow the rules. The judge is like, au contraire, touche, my friend. Because guess what? You, Carter's lawyer, has failed to abide by this court's clear rules. So you accuse Tony Buzbee of not following the rules? Well, guess what, Mr. Spiro? You didn't follow my rules. Under the court's individual practices in civil cases, and with limited exceptions, a pre-motion letter is required prior to filing any motion. Although Carter's attorney stated that he intended to file immediately a motion to strike the first amended complaint under Rule 12F, he did not give plaintiff the requisite 5 business days to respond. See the judge's individual practice, which, by the way, each individual judge, especially in federal court, has their own rules. And you got to do things by their rules, or they'll just kick back a motion and be like, I'm not even going to read this because you didn't do it the way I said to do it. And they're allowed to do that. Wait for the court to set a motion schedule or state whether any exception to the court's individual practice applied. So if you're going to do that, tell me why you needed that exception. What you did, Alex Spiro, this is unacceptable. Counsel is hereby advised that any further motions filed in violation of the court's individual practices may be denied on that ground alone. So if you do that again, sir, if you do that again and you violate my rules, Mr. Spiro, I'm just going to deny it. I'm going to deny that motion. I'm not going to send it back to you and tell you, Mr. Spiro, you didn't do what I said you were supposed to say, or you didn't do what I said you had to do. I'm not going to do that. I'm not going to give you warnings. I'm not going to treat you like children. I'm just going to deny it. These are pretty stern words from the judge. Pretty stern word. Lastly, although Carter's attorney is entitled to file a Rule 11 motion, which is a sanctions motion, by the way, without first seeking leave of the court, see individual practices. He keeps citing his own individual practices. The court discourages this approach. If he still, so this is just a little wink, wink to Mr. Spiro. So I've already told you what I think you're doing wrong, Mr. Spiro. And if you want to file a Rule 11 sanctions motion, you can. And you can do it without leave of the court. But I discourage that approach. If he still intends to serve plaintiff with a motion for sanctions, the court denies his request to shorten the safe harbor provision contained within the rule. And I believe this is the 21, from 21 days to 1 day. So what that means is, what you have to do if you're going to file a sanctions motion is there's a safe harbor period. You say, hey, Mr. or Mrs. Lawyer, you're doing something wrong. Here's what you're doing wrong. You're violating the rules. So I'm going to give you 21 days to either rescind this filing, change what you did, undo what you did, fix what you did, or else if you don't in 21 days, then I'm going to file sanctions, and I think the judge is going to sanction you. It can be a threat. You know, we've had people do that to us in this exact way where they're saying, like, you better dismiss this complaint. It's a frivolous complaint. Here's a sanction motion. Dismiss this complaint. And we're like, go for it, buddy. Go for it. File it. And never have we ever lost a sanctions motion because we filed a frivolous complaint because they disagreed with what our client said. In fact, every single one of those cases ever that I can remember settled where the defendant paid our client the money they were due. So this is not a new or unusual tactic. But the judge is saying, I'm not going to only give them 1 day. Let's read the footnotes too, actually. So let's read. Carter's motion to strike the amended complaint is denied. No surprise there. By January 10th, plaintiff shall file her response to Carter's motion for an order directing preservation of the evidence. By January 17th, Carter shall file his reply, if any. The clerk of court is respectfully directed to terminate the motions at ECF number 32, 37, 40, 41, and 46. Let's read the 2 footnotes here. First one, plaintiff's lawyers has since responded, arguing that a Rule 11 motion would not be appropriate here. Okay. On the merits, Carter's motion to strike is denied. motion to strike under Rule 12Fs are generally disfavored and will be granted only if there is strong reason to do so. Carter's motion, which summarily asserts that plaintiff's claims are baseless and salacious, does not clear that high bar. So even if you did file it appropriately, Mr. Spiro and Mr. Carter, you would lose on the merits, which is basically exactly what I said when we were reading through how motions to dismiss work versus summary judgment. The judge just wants to make clear this wasn't going to win either way. Whew, pretty scathing. So you may wonder, right? Because Spiro's a pretty big shot. Jay-Z's a big shot. Tony Buzbee's a big shot. Is this judge worried about backlash? Now, this is not to say that there are no federal judges that are in somebody's pocket or no federal judges that are bribed or do something that's wrong. I'm sure it's happened. I'm sure it will happen again. But generally speaking, when you compare a federal judge to a state court judge, it's very different. Federal judges are almost never scared. They are appointed for life. Once you become a federal judge, unless you do something really horrible, that can't ever be taken from you. You can be a judge for so long. You can even be a senior status judge where you do like one trial a year and you keep getting them paychecks. So they're not afraid of somebody supporting another candidate. Just to give an example, like in jurisdictions where state court judges are elected, you have somebody with enough power and money, whether it's lawyers, right? Lawyers support judges or don't support judges all the time. And you have a lawyer like Spiro or maybe Buzbee support somebody running against you, that can make a big deal, make a big difference. Or if you have a private citizen, fund a judicial campaign. Maybe somebody with, I don't know, the amount of money that Jay-Z and Beyonce have. And certain judges may be scared of something like that. Not all of them. And I'm not saying every state court judge. I never use always and never. Okay. But I'm just saying to the next level with the federal court judge, or let's say they're appointed. Well, guess what? Private money or lawyers can affect the people that are elected that appoint the judges in the jurisdictions where they're appointed. But federal judges have almost no fear. I've seen some of the biggest big shot lawyers in the world go up in federal court, and those judges don't care. I've seen my dad, who I would put in that group, but to take a step further, some of these federal judges worked for my dad at the federal prosecutor's office where he was the head of the criminal division. They learned under him how to be trial lawyers, and they are now judges, and he comes before them in practice. They don't take it easy on him. They don't care. They don't give him whatever he wants. They battle it out, as they should. They're going to call it like they see it. They're not going to be afraid to tell it. This is the judge telling Alex Spiro, chill. Stop filing this crap. You're wasting everybody's time. Let's fight this case on the merits. What defenses does your client have? Find discovery, build discovery against the plaintiff's claim, fine. Discredit the plaintiff's claim, fine. File your countersuit. File your affirmative defenses. File your answer to the complaint. Do everything legally that you should do and that you're great at, Mr. Spiro. But don't turn this into a battle like this. Don't sling mud around. Same to Mr. Buzbee, right? Don't sling mud around. But there's a big difference between doing a press conference and saying something in a press conference and putting it in a court filing and trying to use it to get the judge to do something or think a certain way or feel a certain way. Big difference there. And we're seeing a very, very good lawyer. Don't get it twisted. I don't want anybody to think I'm saying Alex Spiro is a bad lawyer by any means. We've seen him at work. He is very good. But this would not be great to get an order like this. A lot of lawyers have thick skins, especially the big ones, especially the really good ones. And this type of stuff doesn't bother them. But it's not great to have this on the record because as we saw Alex Spiro use an on-the-record reprimand against Tony Buzbee, now if somebody wants to sling some mud at Alex Spiro, here it is. So very interesting. I can't wait to hear what you guys think. Please make sure hit the like button if you haven't already. But until next time. Oh, also, let me know if you want more on these cases. If you want more on the Jay-Z cases and the P. Diddy cases. Let me know in the comment section. Can't wait to hear what you guys think of this filing and this whole mess. But that's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter.
If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.